unabashed,
the most unpredictable,
becomes a headline,
the most volatile,
outrageous behavior,
unsubstantiated narratives, a battle of personalities.
Welcome to Grant Tamasha, a co-production of the Hindustan Times and the Carnegie Endowment for International Peace. I'm your host, Milan and Mohsin. A few weeks ago, the Modi government formally notified the rules implementing the controversial 2019 Citizenship Amendment Act, or CAA. The law provides persecuted religious minorities hailing from three countries, Afghanistan, Bangladesh, and Pakistan, an expedited pathway to Indian citizenship, provided they belong to the Buddhist, Christian, Hindu, Jain, Parsi, or Sikh communities. Notably, the law does not provide such a pathway to those who belong to the Muslim faith. The notification of the CAA rules on the eve of India's 2024 general election has kicked off a fresh round of controversy over the law, its implementing provisions, and its implications for the future of secularism in India. To discuss all of this and much more, I'm joined on the show today by Mohsin Alambat. Mohsin is a lecturer in law at Queen Mary University of London, and I'm pleased to welcome him to the show for the very first time. Mohsin, good to see you, and thanks for coming on.
Lovely to talk to you, Milan. Really excited.
So, Mohsin, you are a specialist in constitutional law, human rights. You've written extensively about India's citizenship battles. We'll link to some of your work in the show notes. I want to start by kind of rewinding the clock, taking us all back to 2019. It seems like a very long time ago. This was pre-COVID. In December of that year, the Modi government, fresh off its, sweeping general election victory in May, passed the Citizenship Amendment Bill, now called the Citizenship Amendment Act, or CAA. I think maybe just as a kind of baseline, remind us, if you could, of what exactly the CAA is meant to do.
Yes, and it does indeed feel ages ago when this happened, because lots of things have happened since then. So Citizenship Amendment Act seems to have been making rounds much before BJP came to power in 2014. But it definitely was in the works in BJP circles, the Bharatiya Janata Party that assumed power in 1914, soon after they came to power. And the idea there was to, in many ways, consequentially amend India's citizenship law. So India's citizenship law under 1955 Citizenship Act, like most other laws around the world, gives us different ways to allot or allocate citizenship status, but until then was basically, formally speaking, religiously or ethnically non-sectarian law. So independent of your religious identity, if you're born in the country or you immigrate into the country, the same kind of citizenship laws or the same kind of laws about citizenship status would apply to you. And what Citizenship Amendment Act did was it changed the non-sectarian character of the law. It basically said that if you are a non-Muslim immigrant coming from Pakistan, Bangladesh, and if you're a non-Muslim immigrant coming from Pakistan, Bangladesh, and Afghanistan, you would have a swifter way to Indian citizenship. The other thing it did was it changed the definition of what counted as illegal migrant under the citizenship law, and excluded these communities, non-Muslims from these three countries, who came, by the way, before 2015, from the definition of category of illegal migrant. So the upshot of that was, if you are a Muslim and you are an unauthorized immigrant into the country, you will be treated as an unlawful person who will not get access to Indian citizenship. Whereas if you're a non-Muslim from these three countries who arrived before 2015, you would. So that introduced a religious distinction. And soon after this law was passed, there were tremendous protests across the country, primarily led by Muslims. The visuals were striking. There were Muslim women right on the forefront, challenging the government. And eventually this was questioned in the Supreme Court. So there was a long pause. And just last week, the implementing rules for CAA were released. Supreme Court is still seized of the matter. It hasn't decided the case yet.
So as you mentioned, Mohsin, there is a very long backstory to this law. The government has come out strongly defending it, saying, look, what this law does is basically finish the unfinished business of partition. And what they mean by that is that you had religious minorities who remained in Afghanistan, Pakistan, Bangladesh after partition. They decided later, at some point in time, to move to India to flee religious persecution. I wonder if you could just kind of elaborate for us why this law has long been a priority for the BJP and its allies.
And I do grant that BJP has a point when it says that this is the unfinished business of partition. But its critics basically believe it's more than that. It follows the logic of partition. And partition in 1947 was the result of religious animosity, primarily between Hindus and Muslims. And Pakistan adopted a religious system, and it adopted a system in which Islam eventually became the religion of the state. Whereas India adopted a secular constitution and a secular law, a non-sectarian law for citizenship. What the CAA, according to its critics and according to me, does is it adopts precisely the logic that led to partition, and the logic which the partition, as we know, could not resolve, which is of religious animosity. More specifically, I think for the BJP in 2015, there were both political incentives, but more sort of long view ideological incentives. So the political incentives were, I think, primarily in the eastern state of West Bengal. And what was happening in that state was that BJP wanted to capture power in the state. And this is, on the eastern front in India, tremendous populations, which are called refugee populations, who came into West Bengal not only in 1947 because of the violence during partition, but also in 1971 because of the horrendous war crimes committed by the Pakistani military, both against Hindus and Muslims, by the way, because it was against the whole population there. But moreover, that border was porous, and there were populations moving in and out, migrants were moving in and out, and even using the category of migrant is a bit of a misnomer there. So these populations are living together, and they have, in many ways, acquired documentation. They lived as citizens. They were citizens for all practical purposes. What the BJP wanted to do was to use this opportunity to tell its potential Hindu constituents that it will formalize, quote unquote, their citizenship, while at the same time signaling to its larger constituency that it will identify the Muslim outsider and push them out or disenfranchise them. And that was for them a platform, a pitch in West Bengal. And it's a very important state where BJP has not won for very long, in the state elections at least. So that was a more immediate sort of political agenda. I think the long view ideological agenda really was to imagine India as a Hindu state or a Hindu Rashtra or a Hindu nation. The word Rashtra as a Hindi or Sanskrit word is the word for nation. And in many ways, BJP ideologues considered this law necessary to establish India as some sort of like a law of return, India as a country for Hindus around the world, and a law that identified Muslims as a suspicious outsider. And that's sort of really part and parcel of the ideological fabric of BJP, which is the ideology of Hindutva, which believes that India is a nation, a society, a country, a state of Hindus.
So if you read what critics have written, they have assailed the law as being fundamentally discriminatory. Many of them say that it violates the core constitutional doctrines of equality before the law, as well as equal protection. The government, on the other hand, says, look, it's fully within our sovereign jurisdiction to fast-track citizenship for individuals or groups who have faced persecution. I was rereading your piece, which we'll link to, from 2019, called The Constitutional Case Against the Citizenship Amendment Bill. This is when it was still a bill and not an act. What do you think are the most persuasive, constitutionally grounded arguments against the CAA?
So the public justification for CAA for the BJP, which it made both outside and inside the Supreme Court, has been that Hindus in particular, but non-Muslim minorities from Pakistan, Bangladesh, and Afghanistan have been subject to tremendous religious persecution. Another sort of overlapping justification has been what you just mentioned, which is that India has some sort of a historical duty, not necessarily towards the Hindus per se, but towards Hindus in Pakistan and Bangladesh, because this is related to partition after all. And if Hindus continue to get discriminated or persecuted in these two countries, then which other country would address that or receive them? So these are sort of the public justifications that were made. The criticism against the law, primarily the legal and the constitutional criticism, has been to basically challenge these public justifications. And the main form in which that criticism has been made is in the language of reasonable classification. And I'll explain that. So Article 14 of the Indian Constitution provides equal protection of laws and equality before the law. And one of the doctrinal or the legal jurisprudential features of Article 14 is that likes should be treated alike and different people should be treated differently. And the formula that Indian courts have evolved over many, many decades is this thing called reasonable classification, that state can make classifications among different kinds of people, provided that that classification is a rational classification. It makes sense. Secondly, that that classification makes sense in respect of the purpose of the law. So really, it's sort of a rationality test. And what the critics of the law have basically said is that if your purpose is to protect people from persecution, particularly minorities from persecution, why are you restricting the protection of this law only to non-Muslim minorities? Because there clearly are Muslim minorities in these three countries, Shias in particular, Ahmadiyas, who do face religious persecution. Moreover, why is it that if you are interested in religious persecution as well, why are you then leaving out other countries that are in your neighborhood? So what about the Buddhists or in Tibet, or Hindus in Bhutan, or Tamil Hindus in Sri Lanka, or Muslims for that matter, Rohingyas in Myanmar? So for the critics, it just doesn't add up. Now, this is a criticism which I wrote about quite early when the law was passed. But increasingly, I've come to the view that the stakes of this are much bigger than that. Basically, what happened since 2019 is that there has been a creeping re-articulation of rationality tests under the Indian Constitution. So increasingly, several senior lawyers in India have started to defend Citizenship Amendment Act, and basically to say, I think, two related things. One is that this test of rationality isn't as strict as the critics are making it out to be. And the government does have a fair amount of leeway to choose what kind of classes it can create. Second related argument is that under the Indian Constitution, there is no entrenched test for citizenship. And if one reads the text of the Constitution, it seems to suggest that Parliament does have a fair bit of discretion to decide the rules of citizenship. And both these sort of related arguments have been made publicly to say that CAA cannot really be called unconstitutional, or at least it's not an open and shut case as it may have appeared in the beginning. And increasingly, I think the critics of the law, including myself, have started arguing that the real challenge, the legal question here, is about constitutional identity. If India is a secular country, and citizenship status is fundamentally a constitutional question, which relates to the very foundations of the polity, it cannot be that the test for citizenship in a secular country is a sectarian test. That Hindus will be given citizenship, but Muslims who are exactly in the same conditions and same circumstances will not, purely by virtue of religious identity. And ultimately, when the Supreme Court will decide this case, it'll really have to make up its mind about the future course of what constitutional identity of India, particularly secular identity of India, means.
Mohsin, let me just kind of push you a little bit further on this, because what spokespersons of the government say in response to what you just said is, look, if you belong to one of these 6 religious communities, you arrived in India before 2015, you came from one of these 3 countries, you will be given an expedited pathway to citizenship. Right? The residency criteria has been brought down. Now, if you are a Muslim in the similar situation, it's not as if we are telling you you're not going to get citizenship. It's just that you will have to wait longer. Does that argument change the logic you just laid out at all?
No, it doesn't, because it's factually inaccurate. Let's go back to where I started from. In 2003, there was a change in the Indian citizenship law, and the category of illegal migrant was introduced in the law. And basically, the category of illegal migrant said that anybody who unlawfully enters into the country or stays unlawfully in the country would be treated as an illegal migrant. And illegal migrants will be completely disqualified from Indian citizenship. So illegal migrants cannot be naturalized, they cannot be registered, all the other procedures that are provided under the legislation. More worryingly, if a child is born in India to an Indian parent, and the other parent happens to be deemed to be an illegal migrant, even that child will not qualify as an Indian citizen. So the 2003 amendment had huge consequences for Indian citizenship, but it was not a sectarian law. So one could make arguments around statelessness or precariousness of children, particularly who are born, discrimination definitely, or under-inclusion or refugees, because most of the refugees who come in would most likely come in an unauthorized fashion and therefore would be deemed to be illegal migrants. So all those arguments could be made, but it was not sectarian. What the 2019 amendment does is it exempts Hindus and other non-Muslim communities from the category of illegal migrant. So when the government says, we are not stopping Muslims from getting citizenship, at one level it's true. There's no law which says Muslims will not be given citizenship. But Muslims who would be deemed to be illegal migrants can never get citizenship, and their children can never get citizenship. But exactly the same kind of people, if they happen to be Hindus, would. And therefore the distinction is non-Muslims will get an expedited pathway to citizenship. Muslims in the same context will never get citizenship.
I want to just ask you about another peculiarity, I guess you could call it, of the law. In, again, that same article in January 2019, before the CAA was passed, you wrote, and I want to quote here, "The fundamental constitutional flaw in the proposed amendment is that it is not based on an assessment of actual persecution," end quote. I'm not sure how many people know that there's really nothing in the law or even in the rules, which have just been notified, and we'll get to those in a second, nothing in those two things that compels migrants to declare or validate religious persecution. Is this unusual? Is the government acting here on the assumption that, look, by virtue of belonging to these groups in one of these three countries, you were de facto persecuted? Is that the logic?
Absolutely. It's not unusual, but it's not surprising at all. Because the political incentives for the government is to tell its potential constituents, because they are cultivating a Hindu constituency in different parts of the country, particularly West Bengal, and relieve them of the worry that they will be asked to prove anything. And that is why when I introduced CAA, I said the public justification is that. But when we look at the words of the law, there is no mention of the word persecution. Basically, what the government is practically doing is, it is telling the court and telling the world that we want to address persecution. But in the nitty-gritties of the law, the people who are meant to take the benefit of the law are being told separately that don't worry, we are not really worried about you proving persecution. Now, I have other problems with, the different governments trying to set up mechanisms to prove persecution. I think that has to be done in a very careful, dignified manner. But I think it really reveals the political agenda of the government here. That it is really emerging out of the imagination of India being a Hindu country rather than India receiving persecuted people. Because if it was the latter, then we would see the word persecution and we would see a mechanism of testing. What is persecution? Ideally, a humanitarian, refugee law-oriented, a meaningful, responsive, transparent way of testing that, but nevertheless, a system.
Although the CAA was passed in 2019, the government waited more than 4 years to publish the rules implementing the legislation. Those rules were finally notified just a little while ago on March 11th. Tell us a little bit, Mohsin, in your own words, what do the rules say? And kind of second order question, why do you think it took so long for them to get formally notified?
So let me take the second question first.
Sure.
I think the response to CAA was so immediate and in many ways so dramatic, both among Muslims of India and the civil society and the human rights community, but also perhaps more importantly what was happening in the eastern part of India, which I'm assuming we are going to come to very soon, in the state of Assam, where there was this long historic concern around non-Assamese immigrants being settled in the state. And that reaction was so visceral that I think it gave the government some pause. Part of it may also have been the international reaction against the CAA, and particularly in conjunction with this other animal called the National Register of Citizens, again, which we'll come to. So the moment perhaps was not right. I think the more interesting question is why now, right? So it took so long. Why did they do it now? And the answer to that is because elections are just about to start. And the Model Code of Conduct, which is a semi-legal system that the Indian Electoral Commission, the Election Commission of India, implements right before elections, prohibits governments from introducing new policies right before elections so that it doesn't influence voters. So this was perfectly timed right before the Model Code of Conduct was introduced in order to generate this constituency. Now, what was your first question there?
So just before I get to that, just to point on what you just said, I think another justification is obviously not just to try and change the nature of the game in, say, a place like West Bengal, but also to go to the voters and say, look, we made this promise and we kept our promise, right? Just to pivot to the first part, which is, what's in these rules, right? I mean, we know the text of the law. The law is very short. We'll provide a link to it. You can read it in about 2 minutes. What's in the rules, and was there anything in there that caught your attention?
You're absolutely right. There, on the surface of it, when you read the rules, there is absolutely nothing unusual or nothing striking. I think the most interesting thing about the rules is exactly the opposite, which is they're not interesting. They follow the same bureaucratic logic that most policies of this kind in India tend to follow. I think, and I've just recently written an op-ed in the Indian Express where I express my concern that it actually may harm the potential beneficiaries of this law because of the kind of documentary requirements the rules create. So let me sort of quickly summarize what are the key features of the rules. The first thing is that the rules provide a particular format in which potential beneficiaries would apply for citizenship under the Citizenship Amendment Act. They do it online, they have a set of forms, and there is a certain mechanism which has been created. The second thing is that it provides, the rules provide a set of documents that have to be provided to the bureaucrats to show, or they have to provide series of documents to prove their nationality, that they belong to these three countries, and that they have lived in India for a certain period of time. And definitely they arrived in India before 2015. So those are sort of the documentary requirements. The third is some sort of like a bureaucratic infrastructure which is created. So there's a district level committee and an empowered committee which is created. Say, for instance, the empowered committee has bureaucrats from the postal service and the intelligence service, and they are meant to have, in many ways, the final word. They are meant to assess the suitability of the application. So that is sort of really the mechanics of the rules. I think the worrying thing about the rules, particularly from a refugee rights perspective, is the demands of documents. Indian state is obsessed with documents. This is not an unusual area. In many ways, this is the most consequential because we're dealing with citizenship status of, even according to the government, some of the most marginalized, vulnerable people, which are the refugees. And they are being asked to produce their Afghan passport and their residence documentation from Bangladesh, etc. So that strikes as something rather ridiculous, particularly because the government is claiming that it wants to help these people. The second striking feature is that these bureaucratic machines that are created have absolutely no legal guidance about how they are meant to assess these applications. So my experience in India looking at citizenship claims and citizenship verification is that these bureaucrats will be completely opaque. They will be completely free to decide which application to accept, what not. And perhaps the most worrying is that what the rules assume is that anybody who wants to become a beneficiary has to first come out in the open and say, we are not Indians. We are foreigners. And many of these people have been living in India for generations. We also don't know whether the local police and the local bureaucracy will be incentivized to pick up people and make them fill these forms and declare themselves to be foreigners. We have seen some horrendous things in the past, right? In 1970s, when Indira Gandhi's emergency happened, we know how the police was incentivized to force people to engage in family planning policies. So when I read the rules, I was worried both about its banality, but also the kind of horrific consequences it may have on the ground, leaving aside the question of religious discrimination altogether.
Hey, Grant Tamasha listeners. Thanks for listening to the podcast. Putting this show together each week is a labor of love, but it takes a lot of work to put out a great show every week. If you'd like to support the work we do at Grant Tamasha, please visit ceip.org/donate. Don't forget to subscribe to us on Apple Podcasts, Google Podcasts, Spotify, or on your favorite podcasting platform, so you'll be the first to know when a new episode rolls out. But Mohsin, just one clarification. I mean, if these individuals are indeed, as they are under the rules, required to submit documentation from their originating countries, Afghanistan, Bangladesh, Pakistan, that strikes me as quite a high bar. And so could the sort of end result kind of in aggregate just be a very small number of people who actually benefit because of the nature of the rules and the incentives you just laid out?
It could be. I think you're right. I think it's very difficult to know what the practical consequence of CAA will be. Many of us suspected that, right? When CAA was passed, many of us felt that when this will take a bureaucratic form, how will the government be able to deliver its political promise, however perverse it might be, to the people it is speaking to? There will be immigrants who will be able to produce these documents. We assume documents might be the only way the Indian state will be able to think through complex issues. But by and large, I think it was quite unclear, and it continues to be unclear. It depends on what the life of CAA rules will be. So, for instance, among the list of documents that the rules provide for beneficiaries to prove their nationality, one category is any other document. That's it. So, but we don't know what any other document means. Will that any other document be a letter written by a local bureaucrat saying that I obviously know this guy is from Bangladesh? What will ordinary people have to do in order to get local people write these letters? How much money will they have to spend on this? It's basically impossible to know. But that is the character of the Indian state.
Just thinking of as researchers, wouldn't it be great if, we had to submit a journal article or any other document?
Absolutely. So, and that is why when I read these rules, I was less worried about religious discrimination and more worried about the perverse impact this has on rather fledgling conversation around asylum and refugee rights in the country. Just to sort of for your readers, there is no protection of refugee rights in India. India doesn't recognize the refugee rights regime. It has not, in any meaningful way, under even domestic law, preserved the rights of refugees coming in. There are several hundreds and thousands of refugees living in India from Afghanistan, from Tibet, from Sri Lanka. The Tamils, Rohingyas are there. And of course, there's legacy of partition, and there are people who call themselves refugees, and they are refugees of, say, for instance, the Bangladesh war. There is no comprehensive legislation protecting them. And when in 2019, the Indian government started defending CAA, it basically said this is a law for refugees. That is a language which the state adopted. So apart from the fact that it was a sectarian law which left out legitimate refugees, it also does absolutely nothing to further the conversation about refugee rights, even among the ones that the government is seeking to protect.
So a year ago or so, we did an episode, and we'll link to this in the show notes, about a recent report put out by Refugees International on the state of Rohingya in India, and that was one of the things that came out in the conversation, is that absent a kind of a refugee law, it's very hard indeed to kind of adjudicate some of these claims. Mohsin, I want to kind of now take us to the issue of the National Registry of Citizens, or the NRC, which you had alluded to a while ago. When the CAA was passed back in December 2019, the move was seen in conjunction with this All India NRC, which I guess is, as best as I can describe it, is a proposed bureaucratic exercise that would conduct an all India enumeration of all residents in order to determine who is a legal resident and who is an undocumented alien. Tell us a little bit about why CAA and NRC were seen as inextricably linked at the time, and do you think they should still be viewed in conjunction even today in 2024?
Just a quick background on the NRC. So the 2003 citizenship rules, which we've already mentioned, the key culprit in a lot of this conversation, were the first ones that formally incorporated this mechanism called the National Register of Indian Citizens. The idea there was that the Indian state, the executive, the government, shall have the power to create a register of all Indian citizens based on documentary evidence. The funny thing about the NRIC, National Register of Indian Citizens, is that it wasn't supported only by the BJP, and BJP was not the dominant party pushing that agenda at that time. I think there appears to be, if one just sort of looks at parliamentary records, there appears to be some sort of like a bipartisan view that this is a good direction to move towards. What happens, just as a footnote, after these rules are formulated, is that the BJP at that time loses the elections, the Congress party coalition comes to power, rules for 10 years. It's called the United Progressive Alliance, UPA 1 and 2, the second term. And NRIC sort of goes into the back burner. And NRC or NRIC takes a very different form, which we now call Aadhaar, which are these biometric cards that were issued. And in many ways, the biometric card system emerged alongside the National Register of Indian Citizens. But the idea was that they are meant to do different things. National Register of Indian Citizens was a security concern, primarily in the border areas. And the hope was eventually it will be done across the country. Aadhaar, which was some sort of like an offshoot of this, became a welfare mechanism. There were these battles between the Home Ministry and the Aadhaar sort of entity in those early years about who really should control the data, etc. So there's a story there, and I think there's an indication of how questions of welfare and techno-utopia overlap with questions of securitization of citizenship itself. When BJP comes to power in 2014, it in a way excavates the NRC back as a national security agenda. What has happened before BJP comes to power in 2014 is that the Indian Supreme Court, in rather questionable circumstances, initiates an NRC, National Register of Citizens, only for the state of Assam. And as I had said, the dominant groups in Assam, the Assamese civil society, had historically been worried about so-called Bengali speakers or so-called alleged Bangladeshi immigrants taking over the state. A lot of this is sort of the Indian or Assamese version of displacement theory with very little facts or evidence to support it. And they had landed up at the Supreme Court. They got a sympathetic bench. As it turns out, the Chief Justice at that time was also from the state. And the Supreme Court initiated this digitalization and collection of data and creation of a citizenship registry. So 33 million people of the state had to submit documents. Eventually in 2018, a draft was released where 4 million people were left out. And then the next so-called quote-unquote final draft was released in 2019 where around 1.9 or 2 million people were left out. So that was a historical context within which BJP came to power. And I think BJP already had deep sympathies for Assamese claims, because they understood those Assamese claims really as claims against Muslim Bengali immigrants or Muslim alleged non-citizens. Whereas the Assamese claims were independent of their religious identity. Assamese claims at that time were, we don't care whether you're a Hindu or a Muslim. if you're not an Assamese and you're here, it's a problem. Whereas BJP wanted to frame it and had historically always was invested in framing this as a problem of religion. So it was not surprising that when in 2015, the BJP starts talking about citizenship, it starts to take National Register of Indian Citizens seriously, and it has those 2003 rules to latch on to say that we are authorized to do it. So that, apart from the historical background, the other thing was that the Home Minister, Amit Shah, who's a very influential person in the country, perhaps second only to Narendra Modi, the Prime Minister, explicitly said that the ambition was to implement both of them together. And the language he used was that of quote-unquote chronology. He said, first we'll identify foreigners, we'll have National Register of Citizens, whoever is left out is a foreigner, and then we'll have Citizenship Amendment Act, which means we'll give citizenship to Hindus, which basically means, without using the word, that Muslims will be identified as foreigners, and then we'll do something to them. By then, when the 2019 Act was passed, by then horrific stories about detention centers started coming in from Assam. In fact, my first visit to Assam in 2018 was to detention centers, along with the National Human Rights Commission's team, specifically Harsh Mandar, who was there, and I went along with him. And the visuals from Assam and those detention centers were so horrifying because these people lived in legal black holes, they had been targeted and stigmatized. All of them actually had documents. All of them claimed they were Indians. And it was very clear that they got absolutely no justice. And they ended up being in these states of limbo and state of suspended animation. I think all those stories reached the streets of Delhi and then all over the country. And that is why NRC and CA were fundamentally seen to be working together. Now, the next question is, well, what happened to NRC? I think the backlash against the NRC was such that I think BJP had to pause. And the backlash against NRC was, in a way, not only by Muslims, it was also by ordinary people, because ordinary people realized that 33 million people of Assam had to give their documents, which means everybody, whether you're Hindu or a Muslim or whatever. And that is not going to fly that easily among people. CAA might be popular in some circles, but I doubt whether a policy which says everybody, no matter whether you're a Hindu or a Buddhist or a Sikh, you have to give documents, will be very popular. I think that was the major reason why the BJP has started to tone down the NRC talk. But the question is, what will be the fate of NRC, and will that ever be connected with CAA? I think we should not treat NRC as a thing in itself, but as a symptom of a larger problem. It is a symptom of a culture of documents, a culture of bureaucracy, and a culture of targeting vulnerable people, whether they are based on their religious identity or caste identity. Let me just talk about Assam. What has been happening in Assam, independent of the NRC? There's a system of foreigners tribunals that has been in operation for several decades now. These foreigners tribunals have already declared around 150,000 people, 1.5 lakh in Indian parlance, as foreigners. And these are freewheeling institutions. There's no security of tenure. These are not run by judges. They are basically appointed by governments. There's evidence to show that these members who run these tribunals, they are really obliged to the government for their tenure. So they are not independent organizations. And despite all that power, there has been no legal regulation of these bodies. And they are already declaring many, many people as foreigners. Foreigner tribunal system under the Foreigners Act, which is the legislation, applies across the country. And whether or not the NRC is applied in that form across the country, government has many other mechanisms of even individually targeting people or communities and asking them for their documents, telling them that they are suspected foreigners, and it can really open up all sorts of horrific circumstances. So there's a lot of unease across the country, independent of the NRC. But I think the difference is the NRC would at least apply to everybody, no matter what your religious identity is. If systems like the foreigners tribunals are applied across the country, then we are really looking at really insidious targeting of particularly, I fear, religious minorities in the country.
So, Mohsin, let me just kind of ask you to just elaborate a little bit more on the Assam context, because it's a state that you've written about, you've traveled there, you've done field work. If you go back to the NRC, we don't need to get into the complicated story that led to its creation, but, in short, it was an attempt to try and regulate entry into the state of Assam, a problem that was aggravated by the 71 war between India and Pakistan that led to the creation of Bangladesh. As you mentioned, the register that came out, the sort of final draft, was published, leaving off the names of 1.9 million residents of the state. Raises a lot of very disconcerting questions about what happens to those people. And so in the midst of all of this, you have the passage of the CAA. You now have the notifications of the CAA rules. Just if we restrict our attention to the state of Assam, what do you think the impact of these two things together is going to be? Just to kind of give some additional context, just in the past few days, we've seen the BJP chief minister of Assam, Himanta Biswa Sharma, criticize the rules. He called them a fiasco, right? And he's known to be sort of a hardliner who often sees very eye to eye with the powers that be. So I'm wondering if you could just kind of help us understand, what's the mood there today?
I think the chief minister of Assam has great talents for political obfuscation. And just because he's from the BJP and he's definitely a hardliner doesn't make me feel that he is always in agreement with what the Central High Command says. And the political context is complicated and it may take time to sort of dig in, but let me sort of just introduce that in a nutshell. Assam is a really complicated social tapestry. There are religious communities, there are Hindus, and there are Muslims, and Muslims constitute around 35% of the state. But there are tribal communities, indigenous communities, and a lot of the state is governed by these tribal communities. They have these autonomous councils. So it's a complicated, overlapping governance system. Politically, it's complicated because of its demographic content. And BJP's pathway into Assam was really to consolidate the Hindu vote, but that is not always that easy to do for the reasons I'll come to. The other reason why Assam is important is because it's a very sensitive state. It is the corridor to India's northeast, which is a sensitive place because it borders Bangladesh and Myanmar and China. So BJP will be very careful about the impact that these laws have in Assam. And Himanta Biswa Sharma, who is the chief minister, is a political player. He used to be in Congress party earlier, did quite well, wasn't able to become the chief minister, and then he flipped and joined the BJP and now is sort of an ideological card holder. But there are all sorts of tensions between him and the ideological infrastructure of the party in the state. Now, coming to specifically the rules, I think the challenge before the local BJP in Assam is to make sure that the rules do not create a massive backlash in the state. So unlike many other parts of the country where the BJP has a political incentive to play up the rules and to say that it will help Hindus, in Assam the political incentives are exactly the opposite. Because the worry in Assam is that quote-unquote Bangladeshi immigrants will come in and settle down in the state independent of their religious identity. So that's sort of the balancing act that is happening in Assam. Then there is sort of a bureaucratic or institutional question. So leaving aside the political incentives, what will be the fate of the rules in the state? And again, it's sort of really unclear. So what the local BJP leadership is saying is that only those people who have been left out of Assam's NRC will be able to apply, and therefore it's not much of a problem. But just to sort of indicate again, that shows sort of the ridiculousness of the rules because the people who participated in the NRC were claiming to be Indian citizens. So basically what the local BJP is saying is that the same people, if they are Hindu, will be asked now to admit that they are not Indian citizens and apply for citizenship. The other thing which Himanta Biswa Sharma, the local BJP, is saying is, look at the facts. There's an online platform. There are no applications that are coming in. And I have a feeling that might be the case in Assam. The reason being, there are not any foreigners there, or there are negligible number of foreigners in Assam. And the Hindus, who would be the potential beneficiaries in Assam, always have claimed that they are Indian citizens. So who are these Hindus who will come out and say that we are actually foreigners? This is not going to happen. So in many ways, it is a myth-busting exercise, the NRC rules in Assam, because the Assam BJP had constantly been saying there are millions and millions of foreigners in Assam. And if there are no foreigners applying for CAA, because there were millions of Hindu foreigners also in Assam, that shows that perhaps there were never any Hindu foreigners, or for that matter, any foreigners in Assam. And by the way, there's no data to show, no authentic data to show how many foreigners are there in Assam. I think this is one of the best ways to prove that all that was a myth.
Just another data point to enter in this conversation, maybe just get your quick reflection. On this past Sunday, Sharma revealed the religious composition of those 1.9 million folks who have been left out of Assam's NRC. He said about 700,000 are Muslims, but he noted at least another 700,000 who are Hindus who had been left off, and then various other groups. And then there's still, I think, a missing 350,000 that he didn't elaborate on. What significance do you think these numbers hold, if any?
Just a quick point about the missing numbers. The people who are left out in these 700 Hindus and Muslims are indigenous people of the state, because they were unable to produce documents. There were Hindu Gorkhas from Nepal who've been living in Assam for decades. There were transgender people, because they obviously changed their identity, and many of their families did not, many of their families disowned them, so they could not get their documents. So there were many, many women who were unable to get documents. So the trouble is that when we look at this issue only from a Hindu-Muslim point of view, we are able to see something, but a lot of other facets and forms of discrimination and subordination are completely obscured. In terms of the numbers, we already knew that, because there's no official statement on the division of Hindus and Muslims. But when the second draft came out and I went to Assam, it was reasonably well known that Hindus and Muslims, by and large, have been equally excluded from the NRC. And that is one of the reasons why, perhaps, the local BJP was quite ambivalent about what the NRC was throwing up. Part of it was that they were expecting many more numbers. They were not happy with 2 million. They were not happy with 4 million. They believed there were like tens and tens of millions of foreigners.
I think, the initial response was, well, we want to have a do-over, right? We need to do this process over again.
And the same government that implemented it in sort of indirectly claimed that there are serious concerns around corruption, and Muslims got away with it because all of them were foreigners, and now they are on the citizenship list. And it's a complicated story there, because many Muslims were actually quite happy with the NRC, because for them it proved that they are not foreigners. It proved that. But at the same time, the process of then dismantling or undermining the NRC also started. So there were these multiple double, triple speaks that were happening in the state. And the worry, obviously, in the state for Muslims who've been left out is that if CAA is brought in and if it is implemented the way the Central High Command wants it, it's very difficult to know how exactly they'll be able to get those 700,000 Hindus in the list. But obviously that sort of creates more worry among the Muslims than not. But again, it's almost impossible to know, because what this would require is that the Hindus who've been left out will now come out and say, we are foreigners. It's really unlikely to happen, because as it turns out, they are not.
So, Mohsin, just one final thing, kind of on the constitutionality, if you will, about this move. One of the things that many defenders of the government have been saying, and this actually includes people who are in the government itself, have been saying, look, it's really not that unusual for countries to make refugee determinations on the basis of religion. And they often point to something called the Lautenberg Amendment, which was passed in the United States, I believe in the early 1990s. And essentially what that did was facilitated the resettlement of Jews who were fleeing persecution from the former Soviet Union. It was later expanded to include a whole set of other religious minorities like Christians, the Baha'i, and so on and so forth. And later included, countries like Iran. So, is there a difference between that and what the CAA aims to do?
I believe so. Personally, I think there's nothing wrong in taking into account religion. Obviously, religion is one of the major grounds of persecution. I think India does have a responsibility towards religiously persecuted minorities in its region, including in Pakistan and Bangladesh. I think the most important thing to know is the political and social context in which this is happening. At least two features which we have talked about. One is that what India or the Indian government is doing is a political project or transformation of India into a religiously sectarian ethnic state. It is not the response of a secular, inclusive, just democratic country to address problems of religious persecution in its neighborhood, even if it's piecemeal. So, for instance, the government could have said, we are interested in handling persecution or religious persecution. It's a piecemeal project. There's a current emergency in Bangladesh. We will resettle them. That is not what is happening here. It is part of a political project to reimagine India in a very different manner. And that is not difficult. This is not a speculation. This is part of their public statements. It is what the Home Minister has said. It is what the larger ideological infrastructure and the machinery talks about, that India fundamentally is a Hindu country and it is the homeland of the Hindus who come in, and the particular language of exclusion only of one community. The law could have been very different, for instance, to say that if you are a Hindu immigrant or an Hindu Sikh immigrant who claims to be a refugee coming from Afghanistan, we'll give you refuge. But to say that we'll accept these three countries and include everyone but Muslims, even the language of it is rather patently discriminatory. And the rather signaling, expressive components of the law are quite worrying. The other thing also is, as I said, the legal context in which this law is being made. Because the legal context is the 2003 amendment rules, which exclude Muslims because of CAA 2019 from ever becoming Indian citizens, including the children who are born in the country, only because one of their parents is deemed to be an illegal migrant. I think that is a fundamental problem of equality, right to life, and dignity as far as citizenship is concerned.
So, Mohsin, let me maybe just kind of end this conversation by asking you about the sort of bigger context here. You have a recent paper, which I think is soon to be published in a legal journal, in which you write that citizenship status in India has been compellingly and arguably more consequentially ethnicized through less formal and more insidious channels than the CAA, right? Where we spent a lot of time talking about the CAA, a lot of time talking about the NRC. These are legal mechanisms. But what you seem to be indicating in that statement there that I just read out is if you go beyond that, there's something even more consequential happening through informal institutions, other kinds of social. Just what if you could just kind of elaborate on what are those changes that have taken place in less overt, more informal ways?
So that piece which, Milan, you were talking about was really trying to speak to a range of really impressive writings that has been happening on India on the question of what is the transformation in state and law that is happening under Narendra Modi's government. In fact, you and Madhav Khosla have this excellent piece called The Three Faces of the Indian State, which I think is sort of a really important intervention to really theorize what is this regime doing to India as a state, and what are the different ways in which state and law are being altered or transformed. And I agree with the claims made by you and many other scholars that law is being used to fundamentally alter the way Indian state operates, including turning India into an ethnic state or an ethnocracy, where ethno-nationalist sort of interests and values are dominant, where certain communities are considered to be first-class citizens, where others are considered to be subordinate citizens or second-class citizens. The narrower argument in that piece was to invite scholars to start looking at less formal ways in which an ethnic state can be created. And one of the things that I started noticing in India is that even though law is in some manner a significant way of bringing these changes, it is not the most important way in which these changes are. It is not the most important way in which these changes are being brought about. So, for example, there's no formal amendment declaring India to be a Hindu state. There's no formal amendment which says Muslims cannot be citizens. CAA might be one of the few formal changes that have been introduced, that privileges Hindu citizens or Hindus, say in the citizenship context. But what is happening in much more insidious, and I would say in a much more general manner, in a more dramatic manner, is how rule of law is increasingly being made redundant for minority citizens in India. I think the most dramatic example was recently there were these spate of demolitions of Muslim homes that happened. In fact, they have really accelerated over the last 2 years. And what started happening was that in context of either Muslims protesting or some sectarian violence, zonal authorities would land up in Muslim localities and start demolishing homes without any due process, patently against what the rule of law requires and what Indian law and legislation require, quite often even against what the court was saying. And all these demolitions were happening in context of extreme ethno-nationalist mobilization by right-wing organizations and were publicly justified, quite often by the state, sometimes forgiven by the courts for upholding ethno-nationalist values. So, for instance, on grounds of national security, law and order, treating Muslims as outsiders and fundamentally suspect citizens, as if law didn't matter. And my experience working with communities, particularly Muslim communities in India, and just observing these changes in India and the state of everyday social legality, so to say, in the country was that sure, law is reshaping the state and reshaping society, but a lot of it is happening because law is being made redundant or law is being suspended. And for ordinary Muslims, their vulnerability is becoming perpetual, not only because of law, but also because they can never get legal protection at all. So it was that particular idea of theorizing an ethnic state that is created both by reformulation of law, but also forms of suspending law, moments of suspending law through ethno-nationalist mobilization and for ethno-nationalist values. It is happening in both formal and informal ways. So that was my argument. And what I've seen in places like Assam is exactly that. The Indian Supreme Court, for instance, has held that citizenship verification processes like these foreigners' tribunals actually lie outside the rule of law, that due process does not apply to citizenship verification, that even if we have evidence that police is targeting people with Muslim names and asking them to produce documents, ordinary national justice will not apply to these institutions. I would just call these illegal institutions. And the kind of vulnerability these institutions are creating is not necessarily to render people stateless. So these 1.9 million people, they are not non-citizens formally, right? They are not stateless people formally. They are in some sort of suspended animation. They cannot ever stake claim to protection by the law. And I fear that that is basically what is happening to minority citizens in India, where legal instruments are being used, but they are being used in insidious ways to suspend legal protection for people. And ethno-nationalist values are being used to, in a way, carve out exceptions from ordinary application of legality.
My guest on the show this week is the scholar Mohsin Alam Butt. He is a lecturer in law at Queen Mary University in London. He specializes in constitutional law and human rights. He's written extensively about the issues of citizenship in India, the CAA, the NRC, what's happening in the state of Assam. Mohsin, thank you so much for taking the time. I know you're fresh off a flight, fresh off a sleepless night with a young child. We're really, really grateful that you took the time. Thanks so much.
Thank you, Milan. Always a pleasure.
Grant Tamasha is a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. This podcast is an HT Smartcast original and is available on htsmartcast.com. You can also find us on Apple Podcasts, Google, Spotify, or wherever you get your podcasts. Don't forget to rate and review. It helps others find the show more easily. For more information about the show and to find the writing we mentioned on this week's episode, visit our website, granttamasha.com. Tim Martin is our audio engineer, and Mira Verghese is our executive producer. Thanks for listening, and see you next week.
This was a Hindustan Times production brought to you by HT Smartcast.
HT Smartcast.